see the numbers goes, you know. Yeah, it's fine. Good afternoon, everyone. We are going to have a cracking session on future of Asic. And everyone knows about these, the Hayne report, Royal Commission, and the advisor to the Royal Commission report, Professor Famila Hanrahan. And also, you know, the government implemented part of the reports, and a few are still in discussions. So we have got a government representative, Senator Andrew Black, and also Shadow Minister for Financial Services, Mr. Stephen Jones, and also we have got the foundation founder of these consumer commissions, professorial fellow and the leading lawyer and leading expert in law, similar like Pamela that Andrew Fels, and then we have got the, you know, the Dr. Sean Turnbull talk about all the time about the governance and the how we need to manage all those issues on our Asic. So we got a very strong panel. They are going to talk and they are going to guide us what we are going to do with this future of Asics. So I'm going to pass this one to Professor Alan Fels. So he will take care from now. Thank you.
Thank you, Bala. And I'd like to acknowledge the traditional owners of the lands on which the various ones of us are situated and their elders. I'd like to welcome the whole audience to this very interesting session. I'd like to immediately say that we are using Slido, and the Slido app enables you to participate in this with questions. So the Slido, I think, is going up or coming into operation, and you can join it. In the meantime, I'm really pleased we've got 5 top speakers, including Belinda Gibson, who is about to join us, I think. And I won't go through the bios. Instead, I'm going to ask each person to speak for about 5 minutes, and then we'll go straight to the next speaker. After they've each given us their 5 minutes or so, we'll have maybe 10-15 minutes of discussion between the panel on any issues that have come up. And then we'll have quite a lot of time at the end for questions from the audience. And so we're hoping for a high degree of audience participation and a few minutes at the end to sum up. Now, my role is just at this stage, very briefly, to provide a little bit of background, mainly for overseas viewers who may not know the Australian institutional arrangements regarding financial regulation. So the Reserve Bank does monetary policy and monetary policy alone. We have a separate Australian Prudential Regulation Authority, does prudential regulation for all financial institutions. We have the Australian Competition and Consumer Commission, which does competition questions. It does consumer protection, but in broad terms, it does not do, it's not a primary mover on financial services, consumer protection, a little bit of overlap in some areas. We have the Australian Securities and Investments Commission, ASIC, which is the corporations law enforcer and applier in relation to financial services, and including investor and consumer regulation. It has some other functions, but these are the ones of great interest to us. The states don't play a significant role, it's national. Now, a couple of years ago, we had a Royal Commission into misconduct in banking, super and financial institutions, the Hayne Royal Commission, it was very critical of misconduct, sort of illegal and unethical conduct. It was very critical of what it saw as the failure of Asic to enforce the law properly, and it urged that it should change its philosophy to one where whenever it came across unlawful wrongdoing, it should ask the question, why not litigate? And the Hain Commission also made some recommendations to boost financial services law, mainly, as I said, filling in a few gaps. Subsequently, ASIC has, I think, stepped up its litigation and enforcement efforts with perhaps some mixed success in terms of outcomes. And also, since COVID, one strongly senses that the government is a bit cooler about ASIC being a vigorous law enforcer, and it's also a bit cooler about supporting some of the changes in legislation recommended by Hain. There's also a couple of rather hot short-term issues because the chair and the deputy chair of ASIC have resigned, not over anything unlawful, but it has generated controversy, some of the arrangements that were made in relation to their employment. And so there's a search on now for a new chair. Just with regard to some of the issues around this, a lot of them you'll hear from speakers, but questions of institutional design are of considerable interest. Hain recommended, in effect, there kind of should be an oversight regulator of ASIC, and I think maybe other regulators. That idea's been around quite a lot before. And there are also some questions about who best does consumer protection. The Wallace Commission recommended there should be dual coverage both by ASIC and by the ACCC. Shan has a number of important ideas about building up the regulator from the ground. So you can see there are many hot issues, and I would now like to invite Professor Hanrahan, followed by Belinda Gibson, if she is online, Shan Turnbull, Senator Andrew Bragg, and Mr. Stephen Jones speak for about 5 minutes in that order. So over to you, Pamela.
Thank you, Professor Fells, and hello everyone, both in Australia and abroad. I'm on Gadigal country, which is the land here around Sydney Harbour, and beautiful day it is in Sydney, so I pay my respects to elders past, present and emerging. Professor Fells has given a little bit of background to the Hayne Royal Commission. Royal Commissions are an institution in Australia that allows for an inquiry conducted by an eminent and independent person, in this case, a former Justice of the High Court. And that inquiry has coercive powers, so it can require people who are brought before it to provide information even when it's against their interests to do so. So we had an inquiry into misconduct in the banking, financial services and superannuation sectors, and it reported just on 2 years ago, so very early in 2019. The Commissioner's work was fascinating. I was privileged to be involved on the edge of that as one of the advisors to the Commission. The Commissioner made 4 really important observations about what had gone wrong in the provision of financial services to the Australian households and small business sectors, essentially. The first was that he found, unsurprisingly, that there was a misalignment between the desired conduct and the way in which people were rewarded. So remuneration structures and so on tended to prioritise sales over customer service, that kind of thing. The second issue that he identified was an asymmetry of information and power between very large financial institutions and their clients, who often are at a disadvantage. We have levels of financial literacy in Australia which are not too bad by OECD standards, but certainly not where we would like them to be. And so we know that there are consumers out there who are vulnerable and who lack information and power in that transaction. The third concern that he identified, another long-standing feature of our system, is the conflict between the duties of intermediaries and their personal interests, particularly in their affiliations with financial product manufacturers and the way in which they're remunerated, including various forms of commission payments, which are still present in our system. And the fourth observation that he made about what caused the misconduct that he found in the sector was that there was poor enforcement. So there was a lack of holding entities to account when problems emerged. And as Professor Fels has pointed out, that led to the why not litigate observation, which I can certainly add some colour to if we want to go there. So the work of the Royal Commission leads everybody who's been a regulator in the past, and that includes Professor Fels and me and Ms Gibson, who I think is joining as well. For those of us who have been regulators in the past, you always ask yourself, should I have done something different? You know, should I have run that case or not run this case? Or, you know, how should I have been more effective? But I think there are broader issues in play that we ought to think about, and they really go to what Professor Fels has identified, these issues of institutional design. So the things that I've really been thinking about are whether Twin Peaks, which was adopted as the regulatory architecture in Australia back in 1998, is that still fit for purpose? And I've argued elsewhere that I think financial consumer protection is now a regulatory discipline in its own right. I'm not sure that it is optimally combined with the regulation of securities and financial markets, which have a different set of priorities and use different types of regulatory tools. So I've wondered whether we would be better to have a dedicated financial consumer authority to look after the interests of financial consumers, so as not to set that up in competition or in contrast with the responsibilities that I think ASIC fulfills very well in terms of capital markets regulation and securities issues, takeovers and those kinds of transactions. So I think that's the first institutional design issue. The second one, which was raised by Commissioner Hayne and which I've also commented on publicly, is to do with enforcement and enforcement capability. So in Australia, it's the case that most enforcement action for breach of regulatory requirements, including the sort of regulatory requirements that apply to financial institutions, are actually civil penalty proceedings rather than criminal prosecutions. And in our system, we have a specialist Director of Public Prosecutions at the Commonwealth level who has the expertise and independence to run prosecutions where they are criminal matters, but we leave with the individual regulatory agencies responsibility for the conduct of civil enforcement proceedings, and of course they're far more common than criminal enforcement in our system. So Commissioner Hayne asked the question, should we have something like the DPP that's responsible for running civil enforcement actions in Australia? I think that's a really interesting issue, and I think if we had an agency that was available to all of the financial sector regulators, and we have several of them, we have APRA, as Alan has mentioned, we have ASIC, we have the ACCC as the competition regulator in the financial services sector, but we also have the Money Laundering Authority, AUSTRAC and so on. So all of those agencies make use of civil prosecutions, and there might be some benefit in having a specialist agency that's available to all of those regulators to run that litigation perhaps more effectively, efficiently, and with greater prosecutorial independence than we have in the existing arrangements. The third design issue that comes up is about the oversight of ASIC. ASIC is an outlier amongst its peer regulators in that it doesn't have an independent board. So its peak governance body is a commission comprised of full-time executives who are, if you asked ASIC staff members, and I can say this because I was one of them, who, you know, I sort of parachuted in at the whim of the government of the day and then served for a certain number of years and then move on. So we find that most of our peer jurisdictions do use an independent board to oversee the agencies. We talked about that a bit at the Hayne Royal Commission. I'm in favour of that model. Commissioner Hayne went in a different direction and suggested an oversight, a sort of regulator of regulators model, where we would establish this independent oversight body that would review the performance of ASIC and APRA on an ongoing basis. The government did put out some draft legislation at the end of 2019 to establish a body which is not actually an oversight body, it's an assessment body, which is slightly different. But as Alan mentioned, with the COVID developments here, some of those measures, I'm sure, which are, you know, not for cynical reasons, but some of those measures have been slowed down while we've dealt with the impact of the pandemic on the sector in Australia. So I'm hoping, Sian was talking before about what he hopes to get from the discussion today. I think those institutional design issues, so is it still a good idea to combine financial consumer protection with securities markets regulation? That's the first issue. The second issue is, do we need an independent civil prosecutorial agency in Australia? And the third one is, what are the appropriate oversight arrangements for our regulators? They're the three issues that I hope we'll get to discuss today. Thanks very much.
Thank you. Our next speaker is Belinda Gibson, if available. Belinda?
Yep, I think I'm done now.
Okay. Thanks, Belinda. Over to
Thank you. I'm sorry to join later. I have some technical issues, so there's no picture to come, and I hope you can hear me clearly. Is that okay?
Yes, we can.
Good, thank you. Well, thank you for the invitation to speak. 5 minutes, it's just a statement of propositions, I think, and because I didn't hear the introduction, Alan, I guess we all know we're talking about the Financial Conduct Regulator for retail investors. And I speak from the point of being a parachutee, I think, Pamela, I heard that much. Look, I want to make 3 points. One is the triumph of the Hayne Royal Commission. 2 is a regulatory model that I advocate for, 1 formal official regulator rather than 5 we have now. And I want to talk about the court of public opinion, because I think ultimately what the Hayne Royal Commission exposed was that the regulator in the court system can't move fast enough for the current system. So first, the triumph of the Royal Commission, it exposed a lot of activities in the financial services sector that really didn't withstand the scrutiny of the public eye. And largely those cases originated in the ASIC files, and they'd been subject of extended dialogue, lawyer to lawyer, toe to toe for years. It's probably fair to say that the financial service provider, the banks, weren't minded to take a view on what's the right thing to do, whether or not it was strictly legal or not, and were happy to leave at lawyers at 1,000 paces. But that has changed. And that's the triumph of the Royal Commission. Whatever you think of the methodology and its gladiatorial approach, those financial service providers just could not stand that spotlight, and they've responded very quickly. And now customer support and advocacy is front and centre of their approach to the market. And this is the retail customer service environment that ASIC sought to achieve over many years. And it's using clunky old tools has now been achieved by that spotlight. So now turning to what our current regulatory model is, we have 5 formal regulators in the banks at the moment. We've got ASIC, we've got AFCA, the Bank Code of Conduct Forum, and on the sidelines in the wings, APRA and maybe the ACCC. And I think you have to add to that the courts, because the courts do make the final decision and class actions are alive and well there. And finally, of course, the court of public opinion that is very big, quick to broadcast through means that are not so redolent of factual accuracy and opinion versus objective fact. Now, that's a lot for financial services providers to manage, and it's just not efficient. It's a cost to the market and therefore a cost to customers. All customers, those that suffer and those that don't. So I advocate for one, formal regulator, 4 attributes. 1, independent of any single stakeholder. 2, its job is to consult and determine public interest. That is the driver of all regulators, and it's the change in perspective that I guess I found the most challenging when I became a regulator. But it's that change, that realisation of people from outside, that I think is a better assessor of public interest than people who have been regulators for all their lives in a regulatory office. You have to balance an effective market that enables business and people to get ahead, and adequate safeguards for those left behind. And the debate is always, well, how much of a safeguard do you need? So the attributes of a good regulator are adequately funded and empowered to be agile and effective. And I'll come back to that as my third point. And the other thing that a regulator needs is respect and trust of all stakeholders. And I regret to say that ASIC now needs to rebuild that. So now moving to my third point, the court of public opinion, that has to be harnessed by the regulators and all the stakeholders for good. There needs to be a lot more agility. There must be a much more communication to the market in ways that retail will engage with. The old evidence-based, paper-based system that courts and the currently regulatory model work on is too slow and cumbersome and expensive. It's able to be gamed, and it is gamed. On average, it takes 5 years from a wrongful action to occur until there's a contested hearing. The MFS Global that you and I know about, Pamela, that company collapsed in 2009, and the final court determination was in the last year or two. And who recalls that? I don't think the investors in Mayfair 101 saw it happening very much in their system. So I do want to advocate, with all these reviews that are going on, for a review of the legal paper-based system where we're in a much more complex and internet-based world. Judges have to be able to cut through to the critical issues. They have to say, I'll hear you on this and that and only that. They need to understand that a timely outcome is very important. They need to insist on timetables, not the party's convenience. And, you know, this is what the Royal Commission managed to great effect and achieved outcomes. That's extremely difficult certainly in prosecutions, but maybe there has to be some compromise so that the market can understand quick and early that there is a problem here. So I think that's my point, really. I hope that we can have a discussion about what else in the system isn't working right and what opportunities are there with fintech and regtech to be more effective regulators. I think ASIC needs new tools to be effective. I don't think it's an independent board. I don't think it's a new structure. I certainly don't think it's embedded customer advocates with regulatory powers in a corporation. I think it's disrupt the system and be more efficient. I apologise again that you can't see me and had to pick that up online.
Thanks.
That's all I have to say, Alan.
Thanks, Belinda. Over to Shan.
Can you hear me, Alan?
Yep.
First, I'd like to give special thanks to Bala for inviting me to organise this session. I also wish to thank our panel members for contributing their time and very special viewpoints. My contribution is to suggest 2 corporate governance reforms. These introduce stakeholders as partners to minimise the role of regulators. Ralph Nader pioneered this bottom-up approach with customer donations. It would greatly simplify red tape and the role of regulators. All stakers could become engaged as partners to promote mutual interest as well as democracy. Every citizen stakeholder would obtain votes to elect a firm-specific management committee. They would employ a qualified advocate funded by the firm. Unlike embedded regulators funded by firms, advocates could also become mentors to managers. directors already incur significant costs to be regular compliant. They are interested in providing efficient, fair, competitive services, so stakeholders' co-regulation could be a huge relief. Our current toxic system of governance allows good people to do bad things. The CEOs of our largest banks accepted the Royal Commission being introduced because they mistakenly believed it would establish trust in banks. However, the atrocious systemic problems revealed that the CEOs were either not aware of problems and or did not know right from wrong. CEOs can live in a cocoon of ignorance, as shown in the table. This generously assumes that only 50% of information is lost through each level of management hierarchy. A second assumption is that distortions and bias are not greater than 15%. As a result, 99% of director information can be missing or wrong. Australia has toxic governance because it blindly followed so-called international best practices. These practices introduce unethical systemic conflicts. No education course exists in the world to teach bottom-up ecological governance. This explains why the 3 highly experienced experts appointed by the oldest bank in Australia did not answer their set question as to, quote, what does good risk governance look like? After the bank incurred a record fine for misconduct, they blindly stated mainstream governance is fit for purpose. They then further reduced their credibility with extensive details of how the bank failed in stopping misconduct. The bank again became subject of additional regular undertakings. On 2 occasions when I created a new enterprise, I amended their constitutions to separate the power to manage the business from the power to govern the corporation. Might anyone identify for me for any reason why regulators should not make this a requirement for all public companies? The second reform is to correct what Hayne described as the asymmetry of power and information between retail customers and financial service providers. Can anyone advise me why regulators should not introduce stakeholder co-regulators to improve both customer services and democracy? Combining both reforms preserves shareholder primacy and a way for companies to engage with stakeholders as wanted by BlackRock. BlackRock is the largest investor in the world and wants a new model of corporate governance, so benefits can be provided to all stakeholders. 180 other CEOs of the US Business Roundtable who have BlackRock as a shareholder also want to provide benefits to all stakeholders. This objective would then make corporations a common good to promote global common goods, like avoiding global pollution and other existential threats to humanity. Auditors are appointed to judge the accounts of directors, so directors can be held to account by shareholders. If regulators wanted both auditors and directors to avoid unethical conflicts, they would require audit committees of shareholders. Their failure to do so proves that our regulators cannot tell right from wrong, just like the UK Cadbury Committee. No wonder the chair of the AMP thought it was okay during the commission hearings to introduce numerous changes to a so-called independent report from their legal advisor. As stock exchanges trade their own shares, why should not all companies trade their own shares when self-regulation becomes possible with shareholder identity disclosure? Why should not directors and the public be informed as to who the directors are ultimately accountable to? Why should investors obtain corporate property rights longer than a patent without endowing the ownership to other stakeholders to democratize wealth without taxes? Should directors set and mark their own exams at AGMs? I look forward to your feedback. Thank you.
Thank you. And now Andrew Bragg, Senator Bragg.
Well, look, thanks very much. And I'd like to also acknowledge country and my parliamentary colleague, Stephen Jones. I mean, look, basically, I started my career as an internal auditor at EY, and then I spent a large part of my career before I was in Parliament in financial services. And I have to say that I was quite shocked about the scale of the malfeasance that was uncovered during the Royal Commission. And what I wanted to talk about today is how we can put in place a model to avoid that in the future. And part of that begins with the philosophy for government. So, I mean, it's not the role of regulators to set the policy of Australia. I mean, that's why Stephen and I are stupid enough to run for Parliament. because we can be thrown in or thrown out of office. So we're accountable to the people. That is a renovation next door. So, like, I think it's very important that we are a bit purist on this point about setting rules for the financial sector. I mean, the rules should be set by the Parliament. And then it's very important that there is purity on this point, that the regulators are there to enforce the law. My concern has been over the last 10 years that there have been times where regulators in Australia have been more focused on advocacy and trying to change the law rather than trying to enforce the law that they've had. Now, I have a view that it is always good to try and update laws, and we have proposals before the Parliament at the moment to increase the duties on superannuation trustees. But you know, whether or not the Parliament enacts those laws, it's very important that the regulators enforce the existing laws that are on the books, because the solution here is not to have bigger and bigger statute books. It may be to have sharper and sharper and clearer statute, but the law enforcement capacity of the regulators is very, very, very important. So for me, enforcement is very important. We have in the past few years, after the Murray inquiry, given ASIC in particular, and I guess it's no secret here that the coalition government has shown fidelity to the Twin Peaks model since we created it under Peter Costello. And I remember, you know, when I was studying at uni, reading your textbooks, Pamela, about this. So it's nice to be on this session with you today. And I mean, that is still our position. And what we've tried to do is to put in place new tools for ASIC in particular. So we've given ASIC an intervention power. We've given ASIC a design and distribution obligation. So we're making providers think about their target markets, and we're giving them the authority to withdraw products from the market where they cause consumer detriment. But the key point here is there are more tools, but it still comes down to law enforcement, enforcing the duties that are on the books. So that is the most important point. Now, I'm so sorry about that. Now, the next point is, and I'm almost finished, Alan, is we need to have a focus on regulator accountability. And that's why we have, through the Department of Prime Minister and Cabinet, put in place a regulatory or regulator performance focus, where regulators will be forced to show how they are performing relative to other regulators. And I think that this is not about being a regulator of regulators, but it's about sharing data, working together and comparing performance. Now, for me, performance is about enforcing the law. And the last point is, my view is, and I put this to Josh Friedberg, I mean, I do think that there's more we can do in terms of regulatory coordination, especially in light of our ambition to try and attract investment from offshore, especially in relation to fintech. And so one of the commitments we've already enacted from the Hayne Royal Commission has been to put in place the Financial Regulator Accountability Authority. And that is about looking at APRA and ASIC in particular. But I think that body, or the Council of Financial Regulators, ought to have a mandate to look at competition and innovation, because a lot of the issues when you're looking at fintech matters, and I'm chairing a parliamentary inquiry at the moment into fintech, are about organisations falling in between the cracks. And I don't think that regulators work together enough. COFA is very focused on whatever the government, the executive government of the day want. And that's flexible, but it should also have a focus, in my view, on competition and innovation. So in summary, I want to see the regulators enforce the law. It's not their role to set the law, but it's important that we establish structures so that they can focus also on competition, efficiency and innovation.
Thank you. And now, Stephen Jones. Can't hear you.
How's that?
Now? Okay.
Fantastic. I think that will be the epitaph of 2020, 2021. You're on mute, can't hear you. So those of you who don't know the geography of New South Wales, I'm from south of Sydney, a place called the Illawarra. This is the land of the Dharawal people, so I acknowledge their custodianship of country. Over 30,000 years they have inhabited this beautiful part of the world. Great to be on a panel with my parliamentary colleague and sometime sparring partner, Andrew Bragg. Fantastic to be here with people whose work I've studied as a law student many years ago, Professor Hayne Royal, or watched in your roles as regulators over many, many years. So great honour to be with you. I turn my mind to what I could add in a forum such as this that wouldn't be in the shadow of eminent and learned colleagues, but perhaps a different kind of perspective. And I don't mean particularly the political perspective that I bring to it as a shadow minister. So I thought I'd spend most of my time in this introductory part talking about the importance of, but the weakness of, and the weakness with parliamentary oversight, and a system which is established premised on parliamentary oversight being one of the preeminent forms of regulating the regulators. As a buttress or an introduction to that, I should say that I think it's enormously unfortunate that Mr. Kremen is moving on and that Mr. Shipton will be moving on from their roles, has moved on and will be moving on. I thought they were doing a good job in difficult circumstances, but I also think that at a time when we're bringing through a raft of new reforms, a constant hand on the tiller was absolutely needed, both from the prosecutorial workload, but also the new regulatory workload. So I think that's unfortunate. I hope the ship can be steadied in the transition to a new commissioner. Secondly, I want to say that we expect a lot of ASIC. It has an enormous jurisdiction. And a jurisdiction that is growing, not contracting. I think Ken Hain, in parts of his report that you probably drafted, in part Professor Hayne Royal observed that they are directly responsible for 11 pieces of legislation. The corporations law has expanded by over 150% since it was originally introduced and consolidated in the mid-1980s. If you just look at financial services law, they run the registries, they're responsible for the licensing of financial service licenses, they are responsible for the consumer credit and expanding jurisdiction. So that's just within the financial services, a vast jurisdiction. We expect a lot of them. That is conducted at a time of contested policy, contested resources. And in my submission, an insufficient layer of oversight around that. Let me go to the case for the importance of oversight. It goes in part to that vast jurisdiction, but I want to add one thing to that, a point where I would agree with Andrew Bragg on. Quite apart from its direct jurisdiction, we have handed over to ASIC and other regulators enormous amounts of delegated legislation, and this is expanding, not contracting. I agree with Andrew that it is the role of Parliament to legislate, and we haven't been doing that in the area of financial services. We're doing that. We regularly, in my years in Parliament, introduce and pass through laws that say that are thin streams of legislation with vast meadows of delegated powers and rulemaking authority to the regulators. A couple of arguments I might make about that. If we expect Parliament to be responsible for the laws, if we want our parliamentarians to have more expertise in the markets that we are regulating, in the laws that we're making, then we can't outsource all of that lawmaking power and then not take direct responsibility for the oversight of it. We haven't been. We've literally got laws before the Parliament. Andrew's mentioned one of them, that quite literally say the regulator, sorry, the Treasurer may make a regulation and the regulator may ignore it. Quite literally, that is what the law says. The Treasurer may make a regulation and the regulator may ignore it. So we really have reached quite an extraordinary point in the way that we are regulating this sector. It's complex, it's difficult, it needs to be nimble, but that's not an excuse for us not to be doing a better job within the lawmaking space. Then finally, point 3 to the stuff that I was going to say, which would be a unique contribution. Parliamentary oversight is critical for the reasons that I've talked about, but it's insufficient. It's critical because we need to have a competence within Parliament around lawmaking and then the monitoring of those laws within the financial services sector. And I don't think any of us, whatever side of Parliament we sit on, could testify that we have reached a point of satisfactory competence in a lot of the detail that we are pushing through Parliament. One of the ways of ensuring we increase and improve our knowledge is through the committee system, but it is fundamentally flawed if that is all you are proposing to do by way of parliamentary oversight or by way of oversight. It is flawed because of the time that any parliamentarian can spend or allocate to any one committee. It is flawed because of the political bandwidth that you can bring to it. That is, what are the issues you are going to focus on at any point in time? And anyone who's sat on any of these committees or advised them would tell you when looking at inquiries or looking at things, that the issues that you will pursue when you've got regulators before you, there is a heavy contest. There are literally hundreds of things that you could choose to interrogate in an hour or sometimes only 20 minutes that you have a regulator before you. It is an insufficient means of monitoring and oversight. Even if you had all the time in the world, you don't have all the expertise in the world and you don't have the bandwidth. So there are some things that we must do to improve that. I'd compare the culture that Parliament and the major parties take to the way they deal with the personnel they put on national security and international affairs committees, which have extraordinary both powers and responsibilities within the Parliament. People who serve on those committees from almost the time they enter the Parliament say national security, defence, international affairs are going to be the thing that I dedicate my time in Parliament to, and they are going to be the things that I will develop over a long period of time expertise in. I don't think anyone could argue that that is what we do with any of our economics and financial services oversight committees, and I think we should. But given that we know that there are going to be those, we can improve, but we know there are going to be those limitations on parliamentary oversight, I think it is naive of us to think that that is going to be sufficient, which is why I support and endorse the recommendation of Ken Hayne that we need to have some standing oversight body that provides, my words not his, almost a standing audit capacity. And his proposition, or the Royal Commission's proposition, was one of the significant functions of that oversight body would be to do every 2 years capacity reviews of the regulators. And I think that was an insightful regulation where I think 3 years, Professor Henry, you know off the top of your head, but I think we're 3 years since we did the capacity, last did the capacity review, probably 4 now, of ASIC. Some of it was implemented, not all of it was. And nobody could argue that it wasn't time that we might need to have a look at some of that stuff again. We've focused so much of our time on ASIC, by the way, but in bills before the Parliament, if they go through in the current form, we could be baking in a whole heap of the same sorts of weaknesses with ACPRA that we currently experience with ASIC. So an oversight body that looks at both of the twin peaks would be great. I probably went a bit longer than 10 minutes, sorry, 5 minutes, for which I apologise. I'll stop there and hand it back to you, Alan.
Well, thank you all for those excellent contributions. I find it, what I'd like to do is just to give you an opportunity to comment as panellists on anything that's come up. I find it hard to bring it all together. Maybe I could frame one bit of the question about whether ASIC itself is doing the right thing, whether its enforcement and application of the law is about right now. What is your answer to that? I know that's rather difficult to say with the transition at chair level and so on. The flavour of a Hayne Royal Commission was things are okay providing the regulators, principally ASIC, APRA, enforce the law properly. He sort of seemed to think that was almost sufficient. Of course, he had the oversight point, but what do you think of that as a way of, what do you think of that? And also, what does that lead you to conclude? I mean, several of you have said, no, we want some structural changes. And I think we've also heard from Shan, Belinda, something about ways of doing business, culture changes, and more ambitious structural changes like Shan has talked about. So could I go back to you again in the same speaking order? Maybe Pam goes first, and we'll just go through if people have any further comments in the light of what they've heard, or that question about whether ASIC's more or less on the right track, and, apart from some oversight improvements and some coordination things, we haven't got too much to worry about. Pamela.
Yes, what an interesting discussion. I was thinking while both of our parliamentary representatives were speaking about the work that the Australian Law Reform Commission is doing at the moment. So the last of the recommendations in that Hayne Royal Commission report was that we needed to re-examine the complexity of the current law. And that's relevant to two really important things that we've talked about so far. The first is the scope of delegated legislation. Now, it's perhaps not surprising that people who are lawmakers want to keep that function close to their chest, but the Law Reform Commission will be thinking about whether there's a place for delegated legislation in this highly technical and fast-moving area. And of course, for those overseas people on the call, they'll be surprised to find that even though ASIC and APRA have these kind of shadow lawmaking powers, ASIC through its modification and exemptions power, and APRA through its prudential standards, there's sort of shadow legislative powers, but they don't have formal rulemaking powers like the SEC or the FCA. So I think there's a bit of work to be done about legislative design to see whether there's a proper role for the use of delegated legislation, whether it's being made by the executive or by the agencies themselves. And if you are going to retain that for all the reasons that the Law Reform Commission might be tempted to retain it, how you ought to design that so that it's clear that the people who are exercising that delegated function are doing so within rails that have been very clearly defined by the Parliament and within a perimeter that's pretty well patrolled by the Parliament. So that's the first issue about legislative design. The second issue about legislative design really feeds into Belinda's point about complexity in enforcement. I think that ASIC has attempted to address the problems about lack of court-based enforcement for wide-ranging consumer fault in its sector. I don't want to throw any previous chairs under the bus, but these things wax and wane a little bit, and if you have a chair that's not a lawyer, they're not naturally inclined towards litigation because it's expensive and it's risky and it takes too long and all those sorts of reasons. But the fact that we have legislation which is so complex is and includes what I call redundancy. That is, the same conduct can breach lots of different rules, And those different rules have different fault standards attached to them, different defences, different consequences. We have legislation where the consequence of a civil breach that has no fault element is a bigger fine than the corresponding criminal offence, for example. So there's lots of issues about legislative design that are exacerbating the problems that we have using courts to enforce this legislation. So it's tempting to say, well, ASIC ought to litigate faster, or, you know, my suggestion, they ought to have access to a specialist enforcement facility or a specialist law firm, Commonwealth law firm, to run these civil prosecutions rather than using private law firms of variable quality, which is how they run them now. So you can look at the sort of regulator issues, but the broader issues that Belinda's talking about to do with the fact that, you know, the same conduct you can argue lots of different ways, that it breaches lots of different laws. Courts then get caught in this huge sort of process that takes years and years and years to get through. Storm Financial, which was probably the biggest collapse in 2008, that litigation only ended last year. So that's a sign, that's 13 years of litigation, and resulted, I think, in a $50,000 fine for the principals of the business. So I think, yes, ASIC is trying to litigate more. They're certainly using every opportunity they have to retreat from the why not litigate mantra, I notice, but I think they are trying to up their game with litigation, and they've been fast to move on things like Mayfair, which has been in the newspapers and so on, so that's very pleasing to see. But we need to fix the complexity of the financial services law if we want to use court-based enforcement in any way that's going to be efficient and timely.
Thank you. I wonder if I could make a brief comment on that. With the competition law, it, like all these other laws, has suffered from maybe the love of the drafters of Australian laws in writing them out in great specific detail. Now, with the Competition Act, it is fairly clear, and some moves are occurring in that direction of simplifying it. The US and EU laws are about a page each, and we've got, very long competition law, but there are now serious proposals around, some of them picked up by the Harper Review, to cut it down to something much shorter and simpler. I'm not so sure it's so easy in corporations law. I fear there's an inherent complexity. Anyway, I'll just make that comment, but over to Belinda.
Here we go. Sorry. Thanks for that, Alan. Agree. Interesting discussion. I'll try. There are many points I could perhaps pick up on, but I'll try on your first one about is ASIC an effective enforcement at the moment, and I think we have to accept that enforcement covers more than just heads on sticks at the end of a prolonged court period. 5 years, 10 years is too long for the individuals, for the system, for those that are wronged and want recompense. I am a strong advocate of settle if you can, have an EU, have an agreed pronouncement, and let the market know this particular conduct is not acceptable. When I was at ASIC, prosecuted a number of inside traders and went all the way, but those are intensive actions. But as ASIC, I do think in the consumer retail area has a way to go to be a more effective litigator, but they are working in a very, very clunky system. I hope with COVID we no longer have to have a system of personal appearances and counsel's appearances. The other thing we touched on is delegated legislation, and should Parliament make all of the rules? In an ideal world, yes. In a not ideal world, in a fast-moving world, it doesn't work. I think back to the weekend that we banned short selling. Short selling wasn't permitted. We had a meeting on the Thursday to introduce some rules delegated that fixed up what short selling was And over the weekend, we decided that wasn't even enough and utilised powers to ban. Now, Parliament just cannot make those rules in time. Parliament ultimately did about 3 months later. So I think if we want an agile economy that's meeting what's happening globally, we have to accept that delegated legislation is imperative, but we need some principles. They need to be simple. The third point I just would make is that the complicated rules we have, the 1,000 pages of financial services license regulation, is the outworking of an extraordinary amount of negotiation by every vested interest about who should be exempt, on what basis they should be exempt. I mean, but we have a definition of a retail investor, which hasn't changed in terms of a dollar minimum that you have for 10 years. A lot of people are no longer retail, and that's the loophole that a hell of a lot of financial advisors are going through right now that just gets the certificate that says you're not retail. That sort of agility, Parliament, if it's up for it, should do. But Stephen, I think you need a lot more people who are absolutely buried on both sides of Parliament to get something that's effective in a marketplace where social media is moving. And I again close. Courts need to do some work here.
Thanks, Belinda. That's good. And Shan.
Thank you, Alan. You're doing a terrific job. I'm very pleased with the session. Everybody agrees that there's complexity, and the science of managing complexity says you need matching complexity, and you can't do that top down. The whole assumption of everybody is that you need regulators regulating top down. And it's a problem of chief executive officers. And my approach is to solve that cure is better than prevention. You want to prevent rather than cure, put it the other way. And CEOs have a problem of knowing what's going on down at the front line because they're managing very complex organizations. And the only way they can manage that complexity is by having agile decision-making from the bottom up, not the top down. And if you've got better management systems, bottom up rather than top down, you reduce the load of the regulators. You don't want loading up the regulators with more complexity. You want to, the only way to manage complexity is simplify it into smaller self-managing units. And that is not taught at any of our universities. It's not in the company director's course. They took it out. They said it's not relevant to us in Australia. I was teaching the stuff of stakeholder corporations that have existed for half a century. It was in the John Lewis Partnership in England, the Visa Corporation and the Mondragon Cooperatives. They're all bottom-up stakeholder controlled, and they're self-regulating. And that's the model that I'm trying to get across, but it's not. There's a intellectual black hole in universities and in the social scientists of what the physical scientists know how to create self-governing automobiles and Land Rovers and so on. So I see that you're just it's trying to solve. If you keep trying to solve the problem the same way top down, it's a sign of insanity. And it's just not going to work, and it's just going to, and we've had all these royal commissions because the system is wrong, and you've got to correct the toxic conflicts of interest that are intrinsic in the system, which the regulators don't recognize as being unethical. And if people don't know right from wrong, what's the use of having more regulation? You've got to show them they've got to lead by examples, and they don't. They are counter examples, and that's why people believe they're doing the right thing, but it's good people do wrong things. So that's enough of my bleat. Thank you.
Okay, thank you. Now over to Andrew, and I actually had one little question to throw in at you. I fully understand your critique of regulators advocating. They have no real political legitimacy and often serving their own interests and so on. So let's say that was removed from the scene. How good is the capacity of the public service to advise ministers and of ministers to make the decisions? And that also leads a bit onto Stephen in a moment over, well, how good is the capacity of Parliament? You've already addressed that a bit, but could I just ask that question of you, starting with Andrew?
Well, I mean, I'll give you a frank answer. I mean, look, I think that if you have people who are in Parliament who have industry experience and have seen the good and the bad, I think that makes you a bit wiser. I mean, as I say, was a bit shocked about the scale of the malfeasance that was uncovered by the Hayne Commission. And I have been very keen to ensure that we vigorously enact the Hayne recommendations because I think the financial sector has been, frankly, not afraid of the laws that the Parliament has enacted. I mean, that is the only conclusion that you can take from the Hayne Royal Commission. So I would like, I mean, I know that I've disappointed a lot of my former colleagues in finance by not running all their sort of agendas, but I mean, that's not what Parliament is for. I mean, you're there to represent the people, not to represent vested interests. I think that there are too many people who are confused about who they're representing, frankly, especially as it comes to issues around superannuation, which is a large part of the financial sector. The point I would make, though, is I agree with Stephen. I think it's a shame that that Mr. Crennan and Mr. Shipton have moved off or moving away. I think there is no doubt that Asic was trying to enforce the law and was trying to land some blows. And although not all their initial attempts were successful, I think that they were doing the right thing. And I would like to see Asic continue with that agenda, with the Office of Enforcement that they've got. And I want to see the people who are working in the financial sector, whether they're working at a bank or whether they're working at a super fund, I want to see them conscious that the law is going to be enforced, because that is my personal frank observation, that people are not afraid of the laws that we are setting in Canberra. So therefore, what is the point of us all, flying down to Canberra for half the year if the laws that we're setting are not going to be enforced? So look, I think that the appointments that the Treasurer is going to make are going to be very important here in this space around ASIC, and I hope that that he decides to choose people that have relevant prosecution experience.
Okay, thank you very much, Andrew. So, Stephen, and then we'll go to Q&A.
Yeah, you've essentially asked three questions. I'll briefly address I'll address the first one by pouring honey in your ear, Alan. I think you were probably one of the early trailblazers in what I describe as marquee litigation, whereby the force of the litigation that you took on was not so much the culprit that you had within your sights, but the impact that had on the broader regulated community, that could have been them. And I support that. I think there's the right approach for ASIC and APRA as well. The downside, of course, is you get high-profile wins and also high-profile losses. And ASIC has had high-profile losses, and that can have the absolute inverse effect that a high-profile win is intended to have. And you can't always control the takeout of a loss, by the way. I happen to think that the federal court got it right in the Westpac case. But the takeout on that was really quite something strange, depending on who you asked around the place that we work in. So that's the first thing I'd say. The other thing, I guess, which goes to Belinda's point as well, is that I see litigation as a process. So it might commence with the issuing of writs, the issuing of process documents, but it will often end in a defendant sticking their hand up and an agreed pleading. So, I think it's an important part of the artillery, and I think ASIC immediately post Hain and actually during Hain had got it right. I'll be very concerned if they step back from that. The second question you asked is, does the public service have the capacity that is needed? I describe it, I think the public service is staffed by professional, well-meaning public servants who work under incredibly difficult circumstances. I think just about everyone who answers that question says that sort of thing. I think they struggle in this particular area because of the labour market, because of expertise, and whether it's in the legal services area or whether it's in the economic knowledge area. I think they struggle to hang on to high quality staff who have big paychecks dangled at them by those that they are regulated. So, you know, and that is going to present an ongoing challenge for those regulators. Does Parliament have the expertise? I've already said my piece on that, so I'll leave it there. I think we need more. I do want to actually, on the delegated legislation point, I think that I acknowledge the complexity point that Professor Hanrahan and Belinda Gibson have made. It actually buttresses the point that I've said. If it is thought, I don't agree with everything that we're delegating, by the way. I think the pendulum has swung far too far. But if we think a fair degree of discretion is needed for the regulators in their rulemaking capacity, then that is even more reason why we need better oversight than we have at the moment.
Great. Well, thank you. Well, there also, those comments have added quite a lot to the discussion. And now we have some questions from the audience, and I think they'll be presented. Yes. So let's just go through them. We'll take the first one. What can be done to enforce, to bring about success to the recommendations and to an improvement? Let's deal with that one. And if you wanted to say something as a panelist, go ahead. So over to you. Now, Pamela, I'm picking on you for some reason, so maybe you comment first.
Yes, I'm happy to. Sorry, I'm just trying to read the question. There we are. So, despite egregious behaviour, recommendations that were suggested appear to have made little traction in the financial industry. What can be done to enforce these changes? Look, it's an interesting question. Yesterday, I was talking on the radio about some findings by the Financial Services Union that frontline bank staff didn't feel that their KPIs had been adjusted after the Royal Commission, that they were still required to be very focused on sales, and maybe management was calling it something different. And so I was talking to the journalist about that, and I said, look, these are hard organisations to turn around. The other thing that I think we have to be careful of is it's not the job of regulators to say corporations ought to be nicer. They probably ought to be, but it doesn't get us very far. And certainly, you know, the occasional homily is always part of the regulator's toolkit, and sometimes standing in front of an industry audience and talking about how you ought to be nicer and you ought to put your customers first and so on is helpful, but it doesn't really advance things very much, because at the end of the day, these are private sector organisations. They make money out of selling financial products to customers. That's why we have regulation, because there's an imbalance of power and information between the customers and the institutions. And so there's a market failure there, and we intervene to try and address that market failure. And we do that better or worse, depending on who you ask. So, you know, the question, has anything changed since the Royal Commission? I think Belinda made the point very forcefully that she felt that it had, and that certainly at board and senior management level, nobody was ever asking the question, is this legal? You know, the sort of Rio Tinto question, am I allowed to do this? That certainly at boards and senior management level, there is a greater focus on, you know, how is this going to look from a customer point of view. I don't think that they've baked that into their management structures to the degree that you would want, and I think that's where Sian's insights are really interesting. You know, how do you change the organisation internally so that you need less of that external oversight? We've still got a long way to go. There are competition issues. There are problems with the extent to which fintech is putting sufficient pressure on the existing financial institutions, but they're probably things that Alan's better to comment on than I am.
So just following through this question, others may want to comment, but To Belinda, I just wanted to say, yes, we all noted your comment that things have improved in the financial services industry. Personally, I wouldn't dispute that from my limited knowledge. There has been change. But one concern that you still might have is whether that change is going to be enduring or whether it's a kind of temporary reaction to the Royal Commission and the huge publicity and so on. The law hasn't changed a great deal as a result of Hain. You could argue that already there's some softening of things because following COVID. So is it likely to be enduring or just a passing phenomenon and then we sort of lapse back into the old ways? So over to you, Belinda, but others may want to chip in.
Look, I do think it's enduring. I mean, we're talking decades, centuries. Those in the banks and the huge financial institutions would say some of these lie in tech problems, and they are unwinding those tech problems so that they actually do know what's happening lower down, and a lot of money's been spent just fixing the stack, as it were, so that there's greater visibility. I think the language is absolutely right. I think the days of social media mean that trying to cover it up, that the enormous encouragement given to whistleblowers has changed things. So I do think that the path is right. It's harder to work out what is egregious behaviour happening today. There's always difficult questions of judgment, as Pamela says, that financial services do come at a price and you have a safety net. And the question is, how much should individuals be responsible for their own behaviour? You can see it in Buy Now, Pay Later as to whether, you can definitely see it in that Westpac case and the Wagyu and Shiraz. How much does a financial service provider have to make the decisions of their customers? So I do think it is embedded. I do think it's enduring for the time being. Could it be more? Perhaps. Will laws make it more? I actually don't think so. As I've said, that there are banks have 5 financial conduct regulators now. That inefficiency of cost, that compliance thrust, I think is preventing some of the agility that is going to hold back competitors from being effective competitors. Because those rules are going to apply to everyone, and those barriers to entry, well, I personally think they're a problem, but some medium ground must be found. Right?
Do any of the other, sorry, Belinda.
Yeah,
do any of the other common panelists want to comment on this issue about the change that's come about, whether it's enduring, whether it's in the right direction, or on the contrary, that there hasn't really been much movement in the financial industry?
I was tempted earlier to make the observation, Alan, that if you go through, let's leave aside the cultural shift, and I agree with others who've observed that most of the force of the Royal Commission was the law-breaking and egregious behaviour that exposed, not the recommendations in changing the law that came from it, with all due respect to anybody who had a hand in typing up those recommendations. I feel that, look, if you just go through all of the recommendations, you'll struggle to find many, if any, that weren't recommended by a prior ASIC review, APRA review, Productivity Commission review, Law Council review. All of them were sourced from another review that came from government. So I guess my short answer to your question is most of this stuff has been a long time coming. It was the spotlight of the Royal Commission that made it not just politically possible, but politically essential, that can easily fade again.
Thank you, Stephen.
Any
You summed up my views entirely, that trying to solve the same problem, which is broken. So the system is broken. We've got to change the system, and there's no systemic change in any of those recommendations, just adding more red tape, bureaucracy, oversight, and boards and more laws. It's not the problem. Company directors have a real problem managing complexity top down. It's impossible. And if they could be better managers with having partners with their stakeholders to manage agile complexity quickly from the bottom up, then you wouldn't need the regulator. They'd be self-regulating, but that self-regulating is not taught at management schools. It's just not taught. And so keep on trying to fix an intrinsically broken, toxic system.
Andrew, did you have anything to say on this general issue?
I think Andrew had another appointment he had to go to.
Oh, right, okay. All right. Well, let's go on to the next. I think I'll link the next two questions. How can ASIC promote more effective corporate governance when, as an organisation, it continually underperforms? How can the public's trust be reinstated? And then the next one, actually, sorry, I can't quite read. I've just, yeah. Okay. The one after it was, are the regulators, is the problem they're financially illiterate? That was what the question was saying. And we're appointing the wrong type of people to the regulation, to being regulators. Too many of these positions of oversight are given to non-financial market experts. Lawyers and politicians should leave the market be. Any reactions to those two somewhat similar questions, not quite the same questions? That hasn't already been said.
I think the governance question is an interesting one. I think that's a harsh judgment on ASIC. I think that the ASIC staff, certainly when I worked there and since, are very committed, very talented people. And I don't think that as an organisation that significantly underperforms. I think the Royal Commission did reveal problems with its approach where large financial institutions had engaged in systemically poor behaviour. I think the enforcement response that ASIC used in some of those situations was not optimal, and that was the view that the Commissioner had as well. But I think, you know, ASIC does do a lot of significant good work. The question of whether ASIC has credibility as a corporate governance regulator, given its own governance arrangements, that's actually a more interesting one, because ASIC advocates the sort of accepted model, which Sean would dispute, of course, of the majority independent board and the sort of ASX Corporate Governance Council type approach to oversight, having a body that challenges management, that, you know, brings an external perspective, brings industry experience and so on. So it advocates that for the entities that it regulates, but then doesn't advocate it for itself. So I think if you look at the position in the UK, where they do have a board of the regulator that performs that function in real time, maybe under that structure it has more credibility to impose that model on the entities that it regulates. But that's you know, I readily acknowledge that I've lost that argument, and that others think that this external oversight body is a better solution. And so maybe we should talk about that a little bit more. But I would like to say I think it's harsh to say that ASIC doesn't govern itself effectively. I think there are problems with the way it's set up, that you could adopt a different model, but I don't think that makes it a regulator that lacks credibility.
Okay. Any other comments on that, including the claimed financial illiteracy of the regulators? don't know whether that comes from an economist.
I was going to ask, what is a financial market expert, particularly in the retail world? Is it the financial advisors and the mortgage brokers that probably haven't excelled themselves as an industry in this area? I don't know. I think if you want a regulator that is to be an enforcer, then it has to be led by a lawyer, is my belief. But I speak as a lawyer or a former lawyer, and one who was mainly focused in the capital rather than the retail markets. So there's an interest. I think there's some judgments being made that perhaps make difficult answering the question other than to say don't agree.
Yeah.
I generally don't agree, although I'm sure, as with all generalisations, you can find some evidence to prove it, but it would not be true of the whole. And if I could use that brief comment to beg off and excuse myself, I've got to go and grab my kids. So, thank you so much. It's been a delight to engage with you all this afternoon. I appreciate the opportunity to share a few views, but more importantly, listen to yours. Thank you so much.
Thanks a lot, Stephen. That's great.
Thank you.
So,
thank you very much.
that might bring me on to, there are two related questions. What role should empirical evidence, as distinct from ad hoc stories, play in developing good regulatory policy? Unlike the SEC, our regulators have little capability in financial markets, financial economics research. And then a related sort of question, why is ASIC so different than, for example, the US regulator, the SEC, in promoting openness and joint research collaborations with the academic community in market fairness and market efficiency? Any take on that?
Question for you, Alan.
Well, I'll be interested in your take while I quickly...
Can I say to you, the question of not using empirical evidence in financial markets, and we've veered off retail now to the capital markets, is just fundamentally wrong. If you look at all of the work that ASIC does year on year on the high frequency trading and that analysis, since ASIC got given the supervision of the trading markets, that has been detailed and extensive. The second point then was that why is it different in the US regulator in not promoting openness and joint research with the academic community? And I don't know, maybe things have changed, but I think it probably is because ASIC hasn't got any spare money to do that. The SEC is a much better funded organisation than ASIC. Of course, it has a much larger market to fund. So I think, I mean, that very much to me, in my mind, is the starting premise is just not fair. We've moved away in the retail market.
Okay.
That's all I have to say, Alan. It's time's up, and I'm feeling inclined to be a little more bolshy about defending an organisation that actually is recognised internationally as a leading capital markets regulator.
Yeah. Okay. Any other comments on that and the SEC comparison? There is a question about most Australian regulators don't have an independent board. That's already been touched on by several of you. I don't know if you have anything to add to it. Maybe we could have a word on whether this oversight regulator is a good idea or not. It's sort of been, to a degree, almost commended or supported or not rejected by too many of you. Do you think it would add much value?
The oversight body?
Yeah.
Commissioner Hayne was very keen to have an oversight body. The model that came out at the beginning of last year was not an oversight body. It was a hindsight assessment, right? And they're sort of two different things. Now, I did the work that's in the background paper comparing the governance and oversight of ASIC with its international peers. So I can speak hand on heart when I say that we are out of step with the rest of the world. It's a little bit to do with, for some people on the call will recall that originally APRA had external members on its board, including for, the chair of ASIC was a member of the APRA board and so on. And after the HIH Royal Commission, that model, Neville Owen had significant concerns with that model. And so the government backed away from it. And I think there's always just been this, oh no, why would you do that attitude in Australia. People think if you had external or part-time members of the Commission, which you can have under the legislation, it doesn't require any legislative change, that they would somehow be, rent-seeking representatives of the regulated entities, and it would lead to capture and it would have all of these bad outcomes. I can say now, because parliamentary colleagues are off the call, I actually think it protects the organisation from undue political interference if it has that extra body that buttresses it, because ASIC and APRA can both end up, and certainly are in the superannuation debate at the moment, being kicked around a bit politically, and having a credible board like they have for the FCA in the UK might help to protect it from that level of political interference. It would also give legitimacy to the exercise by the regulator of its rule-making powers, which we've talked about a little bit, on what basis does it make delegated legislation and how do you oversight that and those sorts of things. So if there were a true oversight body, whether it's an external board or an oversight body, that's fine. I don't think a backward-looking assessment authority, which is what we seem to have landed on, will do the same thing, or because what we've seen with capability reviews in the past is that people do them and then the chair of the organisation just goes, oh, thanks very much, I'm not implementing any of that. So, I think capability reviews have their own difficulties.
I think the oversight board just improves the optics for the government. It doesn't help directors have better oversight to prevent misconduct, and doesn't do anything to teach society what is right and what is wrong. And it doesn't remove the excessive asymmetry of power and information between the customer and the service provider. So it's just optics which shows that governments are doing something. So it has political value, but it is just another bit of red tape and expense in the wrong direction, top down, rather than bottom up, and helping managers prevent misconduct. It's better to kill the snake than to have a cure.
Okay, thank you. Well, we're just about finished. Now, I just wanted to provide a moment for the poll, Shan's poll right now. We're taking a poll now, is that right? Okay. I think this gives people a vote, is that right? So if you could quickly vote.
I don't think we have a voting slide there, do we? It has the questions, but doesn't have the sensitive. I don't know how it works.
You have to log into the Slido.
Oh, it's in Slido.
So we log in separately to Slido and it'll just show up on the screen.
Oh, I see. Yes, Slido.
So you have to give us a moment to log into Slido to do it.
Okay, right. All right, I've got it. It's in Slido, not on the screen. Thank you.
Well, some of you will go straight into Slido. Others may not have the...
I had Slido open.
So if you go into Slido, you should be able to sort of pop in the votes. Just like same place when you do questions. Go into Slido, vote.
I see a number of people are, suddenly the number of voters is going up.
Oh, it says 12, is that right?
Yep.
13, it's going up. Okay, people are voting. Yes, they've got to read the questions
Why
first.
don't we
Do our 1 minute.
yeah, why don't we, yeah, okay, everyone does their 1 minute and then we'll just see the result. So I'll just go around, maybe in reverse order. So Shan, and
Thank you, Alan. I think I summed it up in my last statement that we got to solve the management problem of controlling and telling people what's right, educating people what's right or wrong, recognizing conflicts of interest and how to avoid them and minimize them, and changing the symmetry of power to allow the customer more power and information to protect themselves with professional advocates like Ralph Nader had in the United States, and they still exist today 40 years later because they work.
okay, Belinda.
My view is the system we have is not fundamentally broken, that ASIC has to regain some trust and respect. I think it can stay as the consumer regulator. I'm a little agnostic as to who it is, but it seems to be an effective place. And I'm most keen to avoid any sort of changes that just impose cost and inefficiency and detract from the main game, which is a properly regulated financial market that enables people to prosper and ensures that those that need help get that help.
So Pamela, you get the first, you had the first and then you get the last say.
That's wonderful. I think that the two biggest changes in the retail financial services space over the last couple of years have been the introduction of AFCA, the Financial Complaints Authority, which has jurisdiction over a much wider range of customer disputes than its predecessor body just did. And it is not tied to the sort of minutiae of legal rules that worry us. The second thing is the introduction of mandatory codes of conduct, including the Code of Banking Practice. I think Belinda's point about the 5 regulators in retail banking is very well made, and maybe what we need to do is look at significant pruning of the financial services laws that ASIC is required to administer, because a lot of consumer protection is now taking place in other venues and through other more adaptive structures. So maybe that's something worth thinking about. I also agree with Belinda's comments, and just to be clear, I've been talking about the efficacy of ASIC as a financial consumer regulator. I have no quibble whatsoever with its efficacy as a capital markets regulator. I think it does and is recognised to do a terrific job in that area. My question is just whether whether those two regulatory domains ought to be combined or separated.
Thank you. Well, thank you all very much. Now, could we just have the results of the vote? Is that possible? Okay, so the winner is the status quo with enhancements. It just beats the separate consumer regulator. Some support, 4 out of 19 for the new oversight authority. The ACCC, just 2 votes for that. And customer associations, etc., 2 votes for that. So that's it. That is the wisdom of the people. I'd like to thank all the panelists, because it's really been interesting to hear all those views and thoughts. So thank you very much all for listening, and the panelists for participating. And that, over to you, Bella. I think that concludes the session.
Thank you to Alan. Thank you very much, all panelists. And thank you, Bella.
Yeah, thank you for valuable time, the panelists, and contributing the important the discussions on ASIC future. So hope everything will make sense and improve our future direction. Thank you. So I think thanks again, everyone.